Great to have you with us. As always, we begin today with the case of the mentally ill prison inmate who died in a hot shower. A criminal case closed after 5 years with no one held criminally accountable.
Darren Rainey was an inmate at Dade Correctional Institution, a state prison down near Homestead. On the night of June 23, 2012, Rainey was found dead on the shower floor. The Miami-Dade State Attorney's office decided nearly 5 years later that Rainey's death was accidental and that the corrections officers who put him in that shower meant him no harm and acted without malice. But new information has called into question some of the conclusions in that closeout memo and cast doubt on the decision not to file criminal charges.
We'll talk all about all of that with Don Horn, who is the Chief Assistant State Attorney in Miami-Dade, a veteran of that office. He oversees administrative matters for more than 300 prosecutors and the Miami-Dade County Grand Jury. And Julie Brown is a reporter for the Miami Herald who has done in-depth reporting on the case of Darren Rainey and has also exposed some troubling issues and abuses in the Florida prison system. Good morning. Thank you so much for being with us this morning.
Julie, Don Horn, great to have you here. Mr. Horn, the closeout memo, and here it is, exhaustive, 101 pages of information, says that Darren Rainey's death was accidental, but he was put in a hot shower for nearly 2 hours. How was that accidental? Why was that not a criminal act?
I think a couple of issues first. We evaluate cases based on evidence. We make charging decisions based on evidence, and your initial premise is that he was put in a hot shower. We don't have any evidence of whether he was put in a hot shower or not. We know that the water was warm because there was humidity in the shower. We have no evidence of what the temperature of the shower was. However, we know that the shower was not hot enough to burn him anywhere on his body. The characterization of accidental is not a conclusion from our office. That's a designation determination by the medical examiner's office.
Right, the Dade County Medical Examiner
Correct.
is the one, but the State Attorney's Office, you, Kathy Rundle, Kathleen Hogue, the other people who worked on this,
Yes.
accepted her conclusion.
Correct. Now, the accidental is only a designation by the medical examiner's office because it's either going to be a homicide, suicide, accidental, natural. I think I'm missing one. So in terms of the options, the evidence is this was not a homicide, any manner of homicide.
Was it culpable negligence?
We determined there was no culpable negligence. And again, I think you have to start from the beginning. Yes, it's clear that Mr. Rainey was suffering from mental illness, and part of that manifested itself in the fact that he defecated on himself and smeared feces all over his body and over his cell. And that's the reason he was placed in the cell. Not as any punishment, he was put in the cell to kind of clean himself up. He was taking medication that created some side effects that, of course, the correctional officers would not have known. So in terms of charging
They didn't know
them,
he was taking the Solidol, this very powerful antipsychotic drug?
they're correctional officers. They're not the folks, the nurses who are giving medication. They would not have privy to his medical history. That would be a violation of HIPAA.
laws.
Absolutely. And so this combination of things, one of the medications he was taking, one of the complications is it made it more difficult for his body to regulate his internal temperature. And so being in a warm shower would have caused a problem for him, even in a shower as large as this shower was.
You know, as we discuss this, we have photographs from the closeout memo. There
Yes.
are videos involved. Julie,
Yes.
I want to bring you into this conversation. It seems like the linchpin of the closeout memo is this autopsy. Dr. Emma Lou, Miami-Dade medical examiner. And the autopsy really has nothing to indicate that Darren Rainey was, and people have been using the words boiled to death, which is just horrific to even listen to. But there is not one thing in that autopsy that corroborates that in a scientific manner. So what do you make of that?
Well, we're hoping that maybe the medical examiner will allow we have a private consultant that we're using. We're hoping that she's going to let us look at the evidence that the reasons why she came to those conclusions, number one. Number two, I just like to bring up my understanding that even in the case of an accidental death, for example, if you have a child who's left in a bath by a parent who, I don't know, maybe the parent was on drugs or gambling or doing something else, and that child ends up dead. Now, there's no question the parent didn't intend for that child to die, and it's an accident. And this happens in Florida, you know, specifically with children being left in cars a lot. And I just question whether the same conclusion would have been reached had it been a child. And in essence, Darren Rainey was like a child. He was being taken care of. He had mental issues. And I just question whether this idea of culpable negligence was really thoroughly examined.
Can I just follow up on the consultant that you're using? Is that the Herald has hired a consultant?
We're going to use one.
Who is the consultant, and why would this consultant have any more expertise than the
It's
investigators
just a
involved?
forensic pathologist that we're going to use to just go over it and
Like
take a look at
second
it.
opinion?
Exactly.
Kind of thing?
And that brings another question. This was a pretty high profile case. It languished for 2 years before the state attorney and the police even started scrutinizing it.
Well, it languished until you began reporting it, honestly. I mean, you were groundbreaking in your reporting. Then it was reopened and it got a lot of attention. Don Horn, a Captain Darlene Watson, who is the health and safety officer at this time at DCI, went into the shower existed, you know, there, and then, but the controls were in an adjoining janitor's closet.
Yes.
Now, I grant you, it was 2 days after this incident,
Correct.
but she went in there with a meat thermometer.
Yes.
And she measured the water temperature. She said it hurt her hand to even be splashed by the water, but it registered at 160 degrees. And that's 40 degrees hotter than generally is allowed in any institution.
Yes, and that sounds horrific, but it has no relevance to this case. And one, I'm assuming she went in there and just turned the hot water on. This is a tap that has hot water, cold water.
Right.
We don't know what the settings were when Mr. Rainey was in the shower.
Yeah.
We know the water could not have been 106 degrees
Well,
conclusively.
Excuse me, what the officers, the correctional officers that night who put him in the shower,
Yes, sir.
were Roland Clark and Cornelius Thompson.
Yes, sir.
What did they tell you about putting him in the shower and the water temperature?
They took him upstairs, and we've got a portion of this on video. He's got on the Murphy garment. He's cuffed. He says, they take him upstairs, turns the water on. The guard says he steps into the shower to test the water temperature. All you've got is water coming out of a hose, pretty much, out of the side of a wall.
Right.
And then he puts Rainey in, takes the cuffs off, and tries to coax him into showering himself. But there's nothing indicating that someone went in there, turned the hot water on only at 106 degrees or whatever temperature is, and left him there. But we know the water could not have been that hot because there are no burns anywhere on his body.
So what you're doing right now here is just raising questions and raising doubt, and that's really all you would need to do to kill a case.
We have to have evidence to be able to go forward with a case, and then we have to
Beyond
have
a reasonable
and we
doubt
have to have
kind of
sufficient
evidence.
evidence that if it goes to trial, we're going to be able to prove that beyond a reasonable doubt. When
So
I
I want
don't
Julie
thi-
to
I don't think that it's necessary. Don't get me wrong. This isn't a slam dunk kind of case. This is a tough case. I don't disagree with that. But when you have a case like this, my view is we have a justice system for a reason. We have juries for a reason. Do the best thorough investigation that you could do, and then let a jury decide. Why take the decision away from a jury when it is a case such as this one where there was there were 7 inmates that heard him screaming. 7 inmates who testified that they heard him screaming. There was a corrections officer. By the way, a lot of this isn't in your closeout memo. There was a corrections officer that said that he knows that they were using that shower as a torture device. The other inmates said, 5 other inmates testified. They weren't all mentally ill inmates, by the way. They testified that they also had been put into that shower.
Although there was a nurse there who had never reported any kind of injuries in the shower prior to this,
Well-
which kind of refutes what
Well,
those inmates
this is
were
what
saying.
happened, and all the inmates told the detectives this. We never reported that we were put in the shower because we were threatened that if we told anybody, they would put us in the shower again.
And none of that information came out in any other statements that were taken by the detectives. And most of the inmates, they tracked down every person who was inside that unit, both units, that night and spoke with them. Most of the inmates said, oh yes, I love taking a shower in that shower because you could control them. The showers the normal showers were usually cold. They were timed. You press a button, the shower came on, and when the time was up, it cut off, and the water was usually cold. Most of the inmates said, I prefer to take a shower there, and some of the guards even let us set the temperature ourselves. So that's totally contrary to, again, some of the allegations that were there.
Well, there are a lot of contradictions, but
Absolutely.
we want to continue talking about the Darren Rainey case, so stay with us. We'll be right back.
Welcome back. We are in the middle of a discussion about the Darren Rainey case with Don Horn from the State Attorney's Office, Julie Brown, reporter for the Miami Herald. A difficult case in which there is video of the inside of this prison. The closeout memo, Don suggests that the video shows and documents a timeline that is completely different from the inmate's account. That, and especially Hempstead, inmate Harold Hempstead, who is really the main witness here, that his account and the video timeline just don't match.
They don't.
Was that a linchpin for this, for you?
That was one of them, and that was significant because it became apparent to us as we went through the investigation, started reading the documents, that he was the person who provided the most information, not just about the Rainey incident, but the allegations regarding other abuses that had gone on in the prison, and that he'd spoken to other inmates and tried to get them to contact the media, to write letters and do those kinds of things. He became crucial because as we looked at the video, there's a video camera right out of his cell. And based on his testimony at the time,
Is that what we were looking at, this video that we were just looking at?
Yes.
Okay.
Yes.
I'm sorry, go ahead.
He is saying that things are happening at a certain time. He knows because he looks at his watch. Well, at the time he's looking at his watch and as the time he's describing these things happening, he can't see them. How do we know? Because he's got his window of his cell covered up from the inside by newspapers. And
Do we see that in the video?
That's not in this specific video here, but as it plays out over a period of time, we can see he removes the video and at some point goes back on the bed.
Yeah.
Well, what about the other witnesses, though? There were other witnesses that said that they saw the same thing. And also, I'd like to just point out one thing. I'm curious why you focus so much on Harold Hempstead's timeline, and yet the police officers, or corrections officers rather, who were involved in it, they were never asked a timeline. Why weren't they asked a time?
I don't know what you mean by ask a timeline.
Like, what time did you check on Darren Rainey? What time did you put him in there?
We've got the log that was kept at the security desk that indicates when the correctional officers are making their rounds. And the video itself shows them, the various officers going through at different times. So that corroborates that testimony. The time log matches up with the video evidence. There were a couple of crucial pieces of evidence for me that, for me, kind of said this was not an abusive situation. One of them is the soap. If you're putting him in there to punish him, why do you go and get him soap? It doesn't make any sense.
Although
Well,
they did
was
not
covered
give him
with
soap to
feces.
begin
I
with.
understand that. But again, if the focus is I'm putting him here to punish him, what the correctional officer says, Rainey said, once he kept trying to get him to coax him to wash the feces off, okay, I'll do it, go get me some soap. And we've got video corroboration. So we look for corroboration and consistency. We can see the officer going from the second floor down to the first floor. He goes to Hempstead's cell. Hempstead corroborates the fact that the correctional officer gets the soap and he takes the soap upstairs. So if he's getting them soap, this looks like somebody who's trying to help this person instead of
Well,
hurt.
I don't think that they wanted to put him back in the cell with feces all over him. I mean, regardless of whether he got the soap or not, it wouldn't have been a good idea for them to leave him in there for 2 hours. It just makes no sense at all that they left him in there for that amount of time.
Can I ask you a question about Hempstead, Harold Hempstead? You went to what prison? He's in a Tennessee prison now, but he was upstate Florida when you went to visit him to do this interview with him. So you interviewed him firsthand.
Right.
What, in your opinion, in your analysis, what is his agenda? Why would he speak so freely to a reporter?
Well, that's another point of this particular investigation. All the inmates that they interviewed who were still at Dade Correctional wouldn't give any statements. They wouldn't talk because they were in the very prison where they felt that they were being punished and they were afraid. Without exception, almost every inmate that we interviewed or that the police interviewed who were someplace else, upstate, released, in Martin Correctional, Swanee Correctional, all those inmates spoke freely about what happened in there. So right there you have a problem. Hempstead spoke more freely. Obviously he would. When he was farthest away from the prison where this happened, he felt like he was, to some degree, a little bit.
what
let's
is
just point out, let's just point, if I may, let's point out Harold Hempstead, who says he's had a religious conversion in prison,
Right.
is in prison for 161
Right.
years, I believe, because he is a serial burglar. He's no choir boy. But I've got to say, the videotaped interview you posted on the Miami Herald website of your interview with Hempstead, frankly, he strikes me as telling a credible story.
And one might think that, but let me give you another side of
Sure,
this, because
please.
one of the things that he says is, oh yes, Rainey was screaming, and then he stopped screaming, and then I heard a thud, sounded like someone fell, and I knew something was wrong. And so I went up to my cell window, and I'm waving and I'm waving and I'm trying to get the attention of the guards. We've got the video camera right outside of his window. Nothing like that ever happens.
Did you confront him with that discrepancy?
We didn't know. All the statements were taken by the
the
detectives,
Miami-Dade
and I don't know
police.
whether they had the video
Yeah.
at the time they were taking these statements, and I don't know. But that's what he said, and it is totally refuted. So when we're looking for consistency and corroboration, we don't get it with Hempstead. So if we're going to go for
But there
it
were
on
other
a case,
inmates.
oh, there were, but nobody.
There was another orderly, Mark Joyner, who gave a very credible statement that echoed almost everything that Harold said. So much emphasis in that report, 8 pages as a matter of fact, is dedicated to discrediting Harold Hempstead, yet you don't address all the other statements that were made by other inmates who said the same thing essentially that he said.
But if the statements are Mr. Rainey got burnt in the shower, that's a non-starter, because we know
Why?
factually
They're not
that did
experts.
not happen.
These inmates aren't experts.
I
They
understand
wouldn't have known
it,
that.
but you said we ought to bring charges, and justice was not done. We need to leave it to a jury. No. We don't do that. We as prosecutors serve as individual jurors, because we can't bring a case that we don't have sufficient evidence for. You said, well, just leave it up to the jury. I did an executive assignment back in 1989 for a man who was prosecuted accused of poisoning his 7 kids. His name was James Joseph Richardson. The state in Arcadia, Florida did not have sufficient evidence to prosecute him. They prosecuted him and led it up to the jury. The jury convicted him, gave him the death penalty, and but for Supreme Court case Furman versus Georgia that overturned all the death penalties, he would have been executed in Florida's electric chair for something he didn't do, and I'm the person who got him out of prison as a prosecutor. So justice does not dictate just filing cases when there's a
I
horrible
agree.
thing. We can't file against people who we don't have evidence of.
Real
Yeah,
quickly before
Don-
we go,
yeah,
we
go
talked
ahead,
about
yeah.
in the commercial break, and just for the record, why was the decision to not take this to a grand jury?
One of the things that we always are facing, not just in this kind of case, and this is in the same police shooting closeout memo format. So if you've got police shootings, same format. We don't take them, we don't take this, because anything that goes on in that grand jury room, and I'm the counsel for the grand jury, is done in secret. Those transcripts will not be released, so the public would have no idea about what got done.
You wanted
This was,
transparency.
yes, it's transparency, absolutely. This is not a grand jury report. I draft the grand jury reports. This was a specific focus.
We know what it is. I would
Yes.
also point out, I'm not a lawyer, obviously, but the state attorney can file direct information.
Absolutely.
You don't have to go to a grand jury
Absolutely.
to charge somebody.
If we've got evidence,
But
correct.
you say you don't. All right, Julie Brown, great to have you come in. Look forward.
Thank
I
you
know
so
you
much.
were not finished with this story. Don Horn. I know a Don Brown. Don Horn, I know you as well. Thank you for coming in. Really appreciate
Thank you for
it.
having us.
A new relationship with Israel was one of President Trump's campaign promises. Is he delivering? That is one of the questions we ask Israel's former ambassador when he joins us right here next.